Hello, everyone. This is Professor Temple, and welcome to this introduction to legal citation, specifically the Blue Book. So, first, what is citation? I always talk about citation as a code that lets the reader know the authority for a proposition, its weight, and where to find it. So let's just look at an example. Here we have State v. Hardin, 679 SE2D 628, 641, parentheses, WVA 2009, end the parentheses. Now, it may seem hard to believe, but there is a lot of information that is conveyed through this coding. So you have to think of yourself as a citation detective trying to decode whatever's written. So here, State v. Hardin obviously refers to the plaintiff versus the defendant in the case. You may or may not know what the 679 SE2D 628, 641 means. Some students will say, well, that's what I type into Westlaw or Lexis to have the case come up, and that is true. But if you want to know specifically what it refers to, first, the 679 is a volume number. SE2D refers to the Southeast Second Reporter. And you will find out in your research class that cases are put into different sort of collection books called reporters. The Southeastern covers a series of states, including state cases from West Virginia. So a clue. And then the 628 refers to the page that the case starts on. And then the comma 641 tells you that the specific passage that we are talking about is on page 641. We call that a pinpoint cite when we have the starting page, comma, the page where the passage can be found. And then finally, we have the parenthetical. In my experience, this is what novice legal writers forget the most often, and it's often the most important thing. So within that parenthetical, what is housed? Well, first, a reference to the jurisdiction, to the court that rendered this opinion. So WVA in this case does not refer to the state of West Virginia, but rather to the Supreme Court of West Virginia. How would I know all these things? How do I know what the Southeast Second abbreviation, how that added up? And same with the West Virginia. Well, within the Allwood Manual, you will find a table of abbreviations that answers these and many more questions. And then, of course, the 2009 refers to the year in which the case was issued. So our first decoding is done. So as you can see, there are two primary citation guides for legal writers. One is the Blue Book, which is the one we're primarily using. The other is the Allwood Guide to Legal Citation. It doesn't matter which one you use because there is one form of legal citation. Both manuals should get you to the same result. So let's talk generally about when you want to cite. Legal writing is different than writing that you've done in the past. We have different rules about when we need to cite. So we cite a lot. Anytime we make an assertion about the law, we want to cite. If we describe a case, its facts, reasoning, or holding, we want to cite. If we quote directly from an authority, we want to cite. If we paraphrase an authority, we want to cite. And that's because any assertion that we make is more persuasive if it is followed by a citation to authority, right? It sounds better if a court said something than if I said something. So if you have any doubt, you should always err on the side of oversighting. So where are you going to see these citations the most? Well, definitely in the office memo that we'll be building, you're going to see them in the discussion section. You should assume that every sentence in the rule section, in the rule explanation section, requires a citation. In the application section, we're not going to see citations as much. Generally, only a quote would require a citation. And typically, we're not going to see citations in the question presented, brief answer, facts, or conclusion. Again, there may always be a deviation or somebody you're working for, you see them do something in their brief answer, for example, maybe they have a preference that they like to include a cite. If that's the person you're working for, you can include a cite. But generally, the most citations will be found within the discussion section. So how do we do this? Well, typically the best way is to use what we call a citation sentence. A citation sentence is used when the citation supports the entire preceding textual sentence. It opens with a capital letter and closes with a period. So let's look together at this example here. If the sentence, the rule that we're presenting says, implied contracts rest upon the equitable principle that a person shall not be allowed to enrich himself unjustly at the expense of another. Whew, okay, so that's our rule. what do we have next? The next thing that you see there, this blue creek all the way up to the period, is what we will call a citation sentence. So that is typically the best way to cite. There are some people that like to use citation clauses. I despise citation clauses. I would never use a citation clause, but at least some others people would be a little bit more generous. They could say you could avoid citation clauses. A citation clause is used when the citation supports only part of the sentence and it's placed immediately after the proposition it supports and is set off by commas. So you'll see an example here. Iowa courts recognize the tort of outrage and then the citation clause of Smith v. Jones, but distinguish it from the tort of IIED. Okay, I hate this. Why? Well, what do you do when you read a citation in the middle of a sentence? If you think about it, you've probably seen these in some of the cases you've been reading. And what do? Of course, you skip it, right? I don't like people to skip my writing, and I really don't want them to skip the second half of the sentence. So I feel that a much better approach would be to divide that into 2 sentences and have a citation sentence at the end of each sentence. That would be the better approach. When stating rules, avoid textual references to the case the rule comes from. You put the case in the citation sentence instead. So here's an example. The court held in Jarvis that hostility does not require any ill will or acts that impair the value of the property. I probably would not do that because I feel that I can convey the Jarvis part through the citation. So the only place that I normally put something like the reference to Jarvis would be in a sentence of facts, maybe after our key proposition in our case illustration. I might say, in Jarvis, blah, blah, blah happened. But I would definitely not put the court held in Jarvis or the court reasoned in Jarvis because I'd be enough along in my case illustration that I don't need to distract the reader with that. When stating rules, avoid textual references to the case the rule comes from, and again, put that into the citation sentence. So here we show you a way to improve this. So instead of saying the court held in Jarvis, blah, 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 you can just say hostility does not require any ill will or acts that impair the value of the property, and then the citation sentence with Jarvis lets the reader know that that's where it came from. I think that the reader will read your whole sentence if you keep that citation information at the end, whereas if you have it in the middle of the sentence, again, you're risking that your reader might stop reading. Pinpoint citations, I talked about that a little bit at the beginning. You use a pinpoint reference to refer the reader to material that appears on a specific page or span of pages. So, for example, State v. Hardin 679 SE2D 628, 641. The pinpoint cite tells us that the case starts on page 628, but the proposition that we want, where your reader would go to find the rule, is on page 641. You want to include a pinpoint reference whenever possible. You want your supervisor to be able to check you really easily, be able to go and look up that rule and find it exactly where you said. If you're quoting, you absolutely need a pinpoint reference. And then there's a little technicality down here at the bottom about how you can cite correctly a span of pages. I try to avoid doing this unless it just so happens that my quote that I'm using that's critical language starts at the bottom of page 125 and spills onto page 126. A couple of cautionary tales for you. First of all, I want you to not assume that just because you read something in a court case that the citation is correct. First of all, citation forms have changed over the years, so if it's an older case, the citation given in that case is probably no longer according to the Allwood or Bluebook guidelines. Some courts have their own rules or customs that are different from uniform rules, and things change. So you always want to double check. You do not want to just lift out of a case a citation and drop it into your memo and assume that it is correct. Okay, so this is where I would normally take questions. Instead, I'm going to walk you through 3 examples. So the first is, what is missing in this paragraph? So we have a defendant probably cannot establish a claim of self-defense if he shoots the victim while the victim is asleep, even if the victim immediately prior to falling asleep had threatened to kill the defendant. And then we have a citation. Then the next sentence says, in Hardin, and we're going to imagine that we had enough room to write a factual sentence. The court concluded that the state failed to prove beyond a reasonable doubt that the decedent was unconscious when he was shot. The court therefore held that the state failed to prove that the defendant was not in imminent danger, and thus blah, blah, blah. Okay, so what is missing? Well, as we look at this, we can tell that this is probably within the R block of our memo. In fact, this is an example of a case illustration that goes after a synthesis paragraph in the rule explanation, and therefore every sentence of this deserves a citation. So even if that citation is id or id at page 643, something later on in the case, we still need to cite each of those sentences. Take a look at this one and tell me what's redundant. In a 1926 case, the Supreme Court of Appeals of West Virginia held that implied contracts rest upon the equitable principle, blah, blah, blah. Okay. And then we have the citation. Well, if you take a look there, I think you'll see that first of all, we don't need to say a 1926 case. Why? Because it's in the citation sentence. We also don't need to say the Supreme Court of Appeals because our parenthetical there indicates that the W period VA period tells us it's the Supreme Court of Appeals. So again, tight writing is what we're shooting for, so we don't want to repeat anything that we could convey through the citation sentence. Finally, what's wrong here? The Supreme Court adopted a broad reading of the Commerce Clause during the New Deal, see Wickard-Reeve-Filburn, though in recent years the Supreme Court has reined in its broad reading, see blah, blah, blah. Okay. Yes, I hope you remember from earlier that this is that citation clause that I dislike and I don't want you to use. Okay, you may see other lawyers using it, you may see it in your cases, but I'm telling you, you probably would have skipped that second half of the sentence in a general reading because you saw the citation, and we often skip the citation, particularly if it's within a sentence. So again, the best approach, divide that into two sentences.